Hello, my name is Susan Graham, and I want to welcome you to the 6th episode of Beyond Retirement Learning Series. I'm a certified elder law attorney located in Boise, Idaho, and the topic today is ways to administer an estate after someone dies. Now, I know your goal is to gather information and also see if I might be an appropriate member for your team. But I have three goals. One is to help you have a secure future with this information that I provide now and in other episodes. And also provide you some free legal forms that everybody needs, and that's on my website. And I will show you a way to contact me if you feel you want to meet with me to see if I can help and be on your team. There is a form at the bottom of your screen that you can complete at any time or at the end of this meeting, and also evaluate me. So I'll make some suggestions so I can improve. Okay, well, let's talk about what do we do when someone dies? How do you administer an estate? There's some basic information everybody needs. And that basic information is who's in charge? Who has the power to sign on behalf of a dead person? When you're alive, you can sign your checks, sell your house, do whatever you want. But when someone dies, you can't just forge somebody's signature. It really is a formal standard to figure out who has the power to gather up the assets and administer the assets appropriately, pay the bills, and finally distribute it out. So let's talk about someone who has no estate plan in place, no documents. The Idaho Code has decided what do we do. First of all, if you're a single person, what the law says is all of the property goes to that person's children. And if a child dies first, the deceased child's share would go down to the grandchildren, to the children of the dead child. Or if there are no children, it goes up to the parents of the deceased person. And if the parents are gone, it goes up to the grandparents. So again, first of all, if the parents are gone, it goes to the siblings and then the nieces and nephews. And if there's nobody at that level, we go up to the grandparents, go out to aunts and uncles and cousins, and we keep going up. If the person who died is truly single and has no heirs, then it all ends up in the state of Idaho Department of Education budget. Then the problem is, okay, that's who inherits, but who's in charge? Well, the Idaho Code also has a standard for figuring out who's in charge, and there's a priority list. First of all, whoever might be named in a will, and we don't have a will in this circumstance, then it becomes a spouse or children or siblings. There's a laundry list in there. Now, what happens when someone dies and has no plan in place? There are two kinds of assets that they own, or they may own. One would be real property. If they own a home or a lot or condo, something like that, then it's required that their estate be probated. That means somebody has to file some papers with the court and say, hey, judge, appoint me as the one in charge. We call them personal representative here in Idaho. They're also called administrator and executor in certain circumstances. And once they have that power, then they have the right to sign on the deed to sell the property and do whatever else is necessary. Another aspect that can throw you into the probate court is if the decedent has no real property, but the cumulative value of their other titled assets that have no beneficiary designation exceed $100,000, you'll have to probate the estate. This means an RV, certificates of deposit, brokerage account, things like that. When that person is appointed, then they will have a document from the court that says they're in charge. And then they can use that document to gather up the assets. And their job is gather up the assets, protect them, make certain that the appropriate bills are paid, and that ultimately the assets are distributed out the right way. When they get appointed, they will also publish a notice in the newspaper. You've all seen those. It's called Notice to Creditors. That means anybody that's owed money by the dead person has to submit a claim within a limited time period. And if they fail to do so, then they can't come back later on and say, hey, I never got paid. If you don't publish a notice to creditors, then any creditor who feels they're owed money can come forward 3 years after the time of that person's death. And if you've already distributed the assets out, this is a big problem for whomever is the personal representative, because they may be personally liable to pay those bills. So what happens is they gather up the assets, they pay the bills, they publish the notice to creditors, they provide an accounting to all the heirs, and that means, what did I start with, what came in, what went out, what's left over. And the heirs are entitled to see that. And when we do that for our clients, usually what happens is we give a written agreement to the heirs that say, gee, this is the accounting and this is also the proposed distribution. Do you agree? And if they all say, yep, I agree, that's the amount I'm supposed to receive, and they all sign that, we file that agreement with the court, and then within 30 days of it being filed, it becomes a court order. If you don't get the agreement of all the heirs who are supposed to be receiving, and you just distribute the assets out, again, the personal representative has some liability if somebody you give a check to is pretty unhappy and thinks they're entitled to more. They can turn around and sue the personal representative for the extra. I don't know whether they'll prevail, just depends on the circumstances. So if you don't get an agreement of all the heirs before you start distributing the money, then you would want to go to court and get an order from the judge that says, yep, you did a great job. And then when you have that order, you can distribute the money out and you don't have any liability. We always recommend that whoever's handling the estate hold back some money for future expenses that you never thought about. It could be there's some extra taxes due. It could be some bill that you weren't aware of that comes in. So usually we suggest holding back a reserve for future expenses. And then if something comes up, you pay it out of that account. And you don't have to call up the other heirs and say, oops, I gave you too much money. Send me back a check for $762 as your proportionate share, because there's a good chance you'll never see that. Okay, so that's what happens when you have no estate planning documents. You could have a last will and testament. That would be great. That at least says who's going to be the personal representative, who's the one that the decedent wanted to be in charge of handling their affairs when they're gone, and then also where's the property going to go. Usually when we prepare the wills, we refer to what I call a list of stuff. That's who gets the china, who gets the ring, who gets the rug. But then you might also say there's a specific distribution. A cabin goes to a particular person, or $10,000 goes to your church, or the Idaho Humane Society. And then everything else goes to wherever it goes. So when you have a will in place, you just can't wave around the will and the death certificate and say you're in charge if you were the nominated personal representative. That will not necessarily be accepted because it could have been the decedent wrote another will after that, or that they weren't competent when they signed it, or they were under undue influence, or the will wasn't technically done right. Those are different ways it can be set aside. So you must file that will with the court along with a petition that says, hey, judge, I want to be appointed. Please appoint me. You have to give notice again to the heirs. And then assuming that individual's appointed, then you go through the additional steps we spoke about. When there's no plan in place, you publish a notice to the creditors and you gather up the assets, pay the bills, create an accounting, ultimately show the heirs who are named in the will, who gets the property and how much, get them to sign off on it ahead of time, and if they won't, before you make the distribution of their assets, again, go to court and get a court order approving the distribution. A third way of handling an estate when someone dies is if they have a revocable trust that actually has assets in it that's fully funded, or maybe not fully funded. What I'm talking about, and we discussed trusts in an earlier episode, is when a revocable trust exists, it says that whoever created it normally is in charge. But then when they die, who's going to be the backup person? We call that person a successor trustee. The trustee is the money manager. So when someone dies, then how does that successor trustee take over? I'm just going to speak about a single person. It's only slightly different for married people. So if a single person dies with a revocable trust, what will happen is that the person nominated successor trustee will start to gather up the assets. And before they do that, somebody needs to know that they're really willing to take the job. So they have to file a series of documents, and when they hire our office, we file those documents with the court that says, yes, I'm willing to take the job. I'm accepting the responsibility as trustee of this trust. We get a tax ID number for that trust. That individual sets up a new checking account under the name of the trust with their name as trustee and the new tax ID number. Then they start gathering up the assets. They notify all the heirs that are listed to inherit under the trust. And so that means those individuals get a copy of the trust and the trust-related documents that relate to the distribution. There is no publishing to the notice to creditors in a trust. The law doesn't provide for that. So if whoever the successor trustee is feels that there may be some debts out there that they're not aware of, it would be necessary to probate the estate, meaning you have to take the will and file that with the court, saying, hey, judge, appoint me as personal representative so that you can file that notice to creditors to cut them off after the limited time period. Normally that's not necessary, but again, it just depends on the circumstances. So when the trustee finishes administering the estate, gathering up the assets, paying the bills, doing the accounting, then again, they would, in our office, we then prepare an agreement that we send to all the heirs that says, this is what's happened with the money, this is what's left over, this is the proposed distribution for you. And if you all agree, then we distribute the money out to them. If they don't agree, then we file a petition with the court and ask the court to approve it. The nice part about having a revocable trust when we do death administration is we don't have the oversight of the court. We don't have the added expense of the probate and the documents that are required to be filed with the court. So some people really prefer that. Also, when you have a revocable trust that has a clause in it that says if somebody fights about it, they don't get a dime, that's basically considered enforceable in most circumstances. So that's helpful. It also keeps the information private. So if you have a really colorful life, one of my clients gave significant money to his mistress. And most people don't want to talk about that or have that become public information. And when he died, he had a will. So that became a public document in the county where he resided and created a lot of stress and pain and embarrassment for the family. So if you have an exciting life that you want to do something like that, you definitely want to think about using a trust as an estate planning document for the distribution of your assets. So that's what happens when someone dies. The big job is who's in charge, who can sign on behalf of the dead person, and who can make certain that the assets are distributed where they need to be. Now, I mentioned some things have beneficiary designations, so no matter which one of these versions, that's a way you can gather up the assets, whoever's the named beneficiary. If in the trust, someone had a house and they sold it, and then they bought a new house and they forgot to put the new house in the name of the trust, you would have to probate the estate for the decedent. Remember that. That means real property in the name of a dead person. But when people sign trust, they also sign what's called a pour-over, P-O-U-R, over will. That just means probate my estate, but put the assets that have to be under the probate court and dump them into the trust, distribute them according to the terms of the trust. Sometimes people have very small estates, and then that means if you're not going to probate the estate, they have no real property, and they have less than $100,000 of cumulative other assets. It's possible to gather those assets up by filing a small estate affidavit, and you attach a death certificate, and you say, I'm not probating the estate, and I want to get this particular asset. I'm entitled to it. And you take that down to the bank or the Department of Motor Vehicles, and you get the asset titled, transferred to whomever you're naming in that small estate affidavit. Now, you just can't take the money and leave town with that. You have to actually use the money to pay any of the bills that are bills of the decedent, and you also have to distribute the assets out according to the plan. Whether there was no plan in place, that would be the Idaho Code tells you what to do with it, or according to a will or a trust, even though you may not have used those instruments. So I appreciate having the opportunity to talk to you about what happens when someone dies, the series of steps that you have to take to have someone in charge to be able to handle that. Again, remember that you can fill out that evaluation form at the bottom of the screen, and you can critique me, which would be really welcome, as well as if you want to contact me, indicate that, and someone will contact you from my office. The next episode is going to be about how to pay for long-term care. Thank you.